Well, thanks for having me here. As you heard from my career, I spent about 15 years as a prosecutor, both handling domestic violence and sex crime offenses, as well as federal civil rights cases. And I think it's important to understand my own prosecutorial journey to data-driven prosecution, because I never set out to be a prosecutor. Early on in my career, I worked in war zones. I worked in Kosovo and Bosnia and Rwanda and the Middle East. And I went to law school because I wanted to build better legal systems so that we could produce healthier, more productive societies. I thought the American system did a pretty good job at representing the rights of all, particularly the underrepresented in our society. I think I came at the work very much with an idealistic and somewhat naive understanding of how things worked in the United States. And at one point I was working in Kosovo. I was in my armored car going to meet the chief of police of a small precinct in the countryside. And I was working with a prosecutor who was at the US Attorney's Office in Chicago, where he had spent his career prosecuting mobsters. And he told me if I wanted to keep doing the work that we were doing, I needed to be in the system for a little bit. I needed to go work in the American justice system. And I said to him, well, I could maybe be a defense attorney because at the end of the day, I really care about civil rights. And he told me, if you really care about civil rights, you need to go be a prosecutor, because more than anyone else in the criminal justice system, the prosecutors determine whether or not we have fair and just results. Now, I had never thought about it that way. Always thought of the defense attorneys as being the ones to fight for civil rights. But then I had the opportunity to go be a prosecutor myself, and I worked in Washington, D.C. The U.S. Attorney's Office in D.C. handles all of the local prosecutions in addition to the federal prosecutions. And I wound up doing DV and sex offense cases. And from the first day I walked into criminal court in Washington, D.C., I realized how much power prosecutors had, how much power I had, and even more importantly, how ill-equipped I was to make the decisions that I had to make every day. It was clear that every day the decisions that I made as a prosecutor had profound consequences on the lives of others, from victims to defendants to the community at large. And like most early career prosecutors, I had a docket of hundreds of cases. And like most prosecutors, I was making hundreds of decisions every day. What pleas to offer, what sentences to recommend, who should be diverted out of the system, in which cases to dismiss. And yet every day as I made those hundreds of decisions, I rarely knew whether or not I made a good decision or a bad decision. I never had any feedback as to whether or not I was doing things right or wrong. I knew whether or not I won cases or lost cases. I knew whether or not my motions were victorious or not, and I knew which evidence we lost along the way. But I never knew whether or not I was making a good decision. And I think this is the challenge of a lot of prosecutors that are in the system every day. We're given a lot of responsibility. We have to make a lot of choices, and it's hard to know whether or not we're doing a good job. And I think that becomes even harder for prosecutors who handle the high volume cases, domestic violence, drugs and guns. People have caseloads of 200, 300, 400 cases, because every day I knew the prosecutors I were working with were doing their best jobs under the circumstances that they had in front of them. And yet it was hard to know what was working and what was not working. And so I left the U.S. Attorney's Office and ended up spending most of my career as a prosecutor at the Department of Justice, where I handled civil rights cases around the country. As Marion said in the introduction, I worked on hate crimes, I worked on human trafficking, I worked on police misconduct. A bulk of my caseload worked at holding law enforcement accountable for violations of the Constitution, whether that was unconstitutional searches and seizures, illegal uses of force, and more often than I like to acknowledge, deaths in custody at the hands of law enforcement. And so as I traveled around the country, I handled cases in over 30 jurisdictions, from Vermont to Kentucky, Louisiana, California. I even had a case in Guam. All places that were incredibly different geographically, places that were different politically and culturally. And every time I spent time in the criminal justice system, I kept seeing more and more bad outcomes that were leading to bad results, particularly for communities of color, particularly for lower income communities. And with the bad incomes that, with these bad outcomes that were affecting people's livelihoods, were affecting their liberties. Some of them could be remedied with civil rights prosecutions, but more often than not, a lot of these inequities and bad outcomes were baked into the system. And so the more systems I saw, whether they be local prosecutors' offices, local police departments, local sheriff's departments, I kept becoming more and more troubled by the role that the system itself played in perpetuating the harms. And what I found most interesting were how many of those harms were not necessarily created by any one individual's bias or any individual's choices, but a series of collective choices and collective policies that were made by police and prosecutors in the court systems all across America. There were a lot of bad decisions that were being made, sometimes in part because of cognitive biases that we have. You know, each one of us, as I learn more and more, have our minds take shortcuts in how we make decisions. Sometimes we rely too much on the information we receive initially. It's called the anchoring effect. Sometimes we focus in on information that confirms a pre-existing idea that we have. It's called the confirmation bias. And a lot of times we just go along with the status quo because it's what we know, and that's called the status quo bias. And all of these biases are baked into the way our minds are wired, and they're baked into the systems themselves, and they're baked into how our system and our criminal justice system as a whole makes decisions. And these continue to lead to a lot of bad results. And again, they particularly affect communities of color, and they particularly affect lower income communities. And so I wondered over these years, how can we fix this? How can we get beyond the individual cases in front of us? And how do we look more at the system as a whole? Because any one of us and any one of our decisions, when we look back at a particular case, we can justify how we got to that point. But when we take a step back and we look at the whole system and how decisions are made as a whole, we end up seeing a lot of trends and problems in policies, procedures, and the systems themselves. And so over the years, as I was working at the Justice Department, I learned a lot more about how data analysis was being used in different fields, from sports to entertainment to banking, and looking at how data could be used to improve performance, and more importantly, how it could be used to improve decision-making, and from a public policy perspective, how we could use it to make better policy. Now, to be clear, I am not a data scientist. As a prosecutor, I never use data to make any decisions. I once tried to do it in one of my cases, but not surprisingly, the investigative agency that I was relying on lacked the ability to do the analysis I needed. I don't code, and I never took statistics at any point in my education career. And yet, it seemed to me like data had an opportunity to help us solve some of our problems. It seemed like a good way for us to figure out, are we doing a good job as prosecutors, or where could we do better? I know a lot of times when I work with prosecutors and we find problems in the system, whether it's long time to disposition, or whether or not it's a high disproportionate arrest rates, or whether or not it's long disproportionate sentences for community of color, it is easy for prosecutors to point the finger at someone else. Oftentimes, we like to blame the police, we like to blame the courts, and our favorite, the defense counsel. And yet it is pretty rare for prosecutors to look in the mirror and to try to understand, how are we, as the most powerful actors in the criminal justice system, contributing to these disparities and contributing to these inequities. And so about a year ago, I left the Department of Justice and I recruited some data scientists and some policy experts, and I started the Justice Innovation Lab. We formed partnerships with universities like Georgetown and George Washington University. And more importantly, we began building a team and a community of experts with the know-how to build data-driven solutions for a more equitable and just criminal justice system. It seemed to me that we should be learning from our past decisions, where we've made mistakes and how we could fix them. Because it's clear that within our system, there are a lot of problems. It's clear that we incarcerate way too many for way too long, and that we perpetuate inequality with a lot of those decisions. Now, for the prosecutors out there, for those in law enforcement out there, I'm fairly certain that you became prosecutors or entered law enforcement because you thought that the work was going to be consistent with your values, whether or not it was a desire to support victims of crime, whether or not it was to ensure accountability for the crimes in your community, or whether or not it was to contribute to public safety. And I think we've now reached a turning point where the anecdotes that we tell, whether that be our successful trials or our successful wins, are no longer sufficient. We've got to look at our decisions throughout the process to decide whether or not we are being as fair and equitable as we are setting out to be. Are we meeting our goals? Can we measure whether or not we are succeeding? Are the processes and procedures that we've been using for hundreds of years currently serving our goals, and more importantly, our community's goals? And do we have a way of measuring it? Traditionally, we've looked at conviction rates and sentence lengths, but I think it's becoming clear that we can no longer do that. And so we've looked at the tools that we've been dealt with, and it's pretty clear a lot of times we have limited and blunt tools as prosecutors. We prosecute people. We send people to jail. Increasingly in years, we've been turning to diversion as a way to get more and more people out of the system. Because for anyone who has spent any amount of time in the criminal justice system, we see that way too many people walking through the front door are there because of addiction issues. They're there because of mental health issues. And we will never be able to punish or incarcerate our way out of those challenges. And so as we look overall, our goal is to look at the broader system, system-wide decision-making, where there are problems, and to begin to do something about it. A lot of the presenters have talked about using data for transparency, and I support that 100%. Our intention as we work with offices is to make all of our data publicly available. But transparency is only the beginning of this process. For me, we have to begin changing policies, procedures, and changing the way we make decisions to ensure that we're making the best, fairest decisions possible. And what I think is interesting, because a lot of time when we talk about data, particularly disparities in sentencing, a lot of people looked at the homicides and your armed carjackings and the violent crimes. But what may surprise a lot of people is a lot of the disparities within most of the criminal justice system are going to be driven by your low-level offenses, because that is where some of the most disproportionate law enforcement is taking place. So what are we doing? At the end of the day, our goal is to use data for better decision-making and for better policy. So how do we do it? We start with 2 points. Every criminal justice system, and when I say criminal justice system, I'm talking at the county level, because in reality, we've got about 3,000 criminal justice systems in America. There may be some fixes that work across the board because we do have a national problem, and many of those problems are consistent across jurisdictions. But at the end of the day, the processes, procedures, and decisions are made at a very local level. So the first thing we do is we understand the system that we're working with. We do a deep dive in understanding how cases come in the system, what are individual drivers, how is it that you screen cases, how is it that you charge cases, because the individual decisions at the local level are going to make a real difference in how we fix the problems. We then start by receiving the data. The data that we use is all local data, and it is all case level data. Because while you can learn a lot of interesting things at high levels by breaking into categories or by looking at the overall system, if you want to fix problems, we found that you have to really get down to the case level. Because for prosecutors in the systems, we know that DV cases are different than drug cases, are different than homicide cases, and are different than sexual offense cases. And so the solutions to those problems, even where the problems are the same, one of the things I'm going to talk about a little bit later in my presentation are dismissals. And in looking at how an office handles dismissals, because I think as a first data point, I know a lot of the questions today is about where do you start. I think a really interesting part in trying to reform the criminal justice system and ensure that it's more fair starts by looking at dismissals. So we look at metrics across the criminal justice system, particularly as it relates to prosecutors, because as prosecutors know, there's influence at really, as far as I see it, 6 main points. We can't control who comes in our front door, and ultimately we don't choose who gets a sentence and for how long. But the decisions that we make along the way, from bond to diversion, to charge decisions, to plea offers, to sentencing positions, and to dismissals, ultimately have the ability to shape what happens on the arrest end and what happens on the sentencing end. So we look at metrics at each step along the way. For bond, a key metric is how many people are being detained because they are too poor to pay their bonds. The higher that number in your jurisdiction means you have a problem. Who's coming in the front door to begin with? What are the racial and demographic backgrounds, and what are they charged with? I think a lot of us who have been in the system for the last 15, 20 years and have lived and seen some of the harshness of the war on drugs, and particularly the impact that that's had on communities of color, recognize that our systems are loaded with low-level violent offenses. What I think many prosecutors' offices don't realize is just how big of a percentage of their caseload is taken up by these low-level offenses. Most prosecutors don't necessarily believe that is the most effective way to contribute to public safety, nor do we believe that it's the most effective way to address those underlying problems of addiction and mental health. And yet, when we think about how we spend our hours day in and day out in court, a huge percentage of our time is spent on these low-level and non-violent cases. That means that we're not spending time on the homicides. That means we're not spending time with the victims who we need to show up in court if we're going to prove the crimes where people are victimized. And it means that we're not spending enough time being smarter about how we use our limited resources. The reality is every resource we spent doing one thing means that it is a resource we cannot spend on doing something more important. And so I think we start by looking at what's coming in the front door, who is coming in the front door, and trying to figure out, is that where we think that the prosecutorial influence and power is best spent? And then we look at the cases as they move through the system. Are we making fair decisions about who is being charged? Are people who are being charged with the same offenses receiving the same sentences? Is a good way of looking at whether or not we're being fair. But I think it's even more important to say, are people being charged the same way for the same conduct? Because what I've seen in jurisdictions is sometimes people treat charges the same, but we're seeing a massive difference between who gets charged with possession and who's charged with possession with intent to distribute. These are discretionary decisions that people make. And when you see a massive disparity in who gets charged with PWID versus who gets charged with possession, that's a problem of intake. That's a problem of policing. And it's something that as prosecutors, it's our role to make sure that the people in the system are being treated fairly as they go through the system. And so as we look at these metrics at the different decision points, offices then have to make a decision. Where do we want to put our priorities? For me, I always think that your priority should be screening on the front end, because the more time, money, and energy you spend at the beginning of the process, you are going to save money on the back end, but also, even more importantly, you are going to reduce the amount of harm in the system. Again, one of the things that I want to talk about in a second is dismissals, because the quicker you get bad cases out of the system, that means you're saving your own resources, and that means that you're saving you're benefiting the people who shouldn't be there in the first place. And so as we figure out metrics and problems and challenges within your system, you've got to figure out what's the problem you want to solve. And so we've got to deconstruct it. That's why we look at it at the case level, because if your problem is dismissals of domestic violence cases, or your problem is dismissals of gun cases, those are likely caused by two different things. And so your solutions are going to be different. And so how do you find solutions? Partly it can be data-driven. Some offices keep really good data that allow us to get into the nitty-gritty. One of the areas that I want to spend time as we move on in the future is understanding more about how plea offers are made. The problem is I have yet to see an office that keeps sufficient data to really help us understand that problem, because we're not measuring necessarily the right things. One of the things that I think a lot of prosecutors who are entering into data-driven thought have to consider is where we are getting our data from. Almost always it's coming from case management systems. And it's important to remember that the case management system was not designed to make our system more fair. It was made for us to know what cases we have and when should lawyers show up in court and maybe what happened with them at the end. Now, the good news is many of the systems are robust enough that we can find out things like are certain types of cases getting continued more frequently? Are we continuing cases more for defendants of color than we are for white defendants? But a lot of times, you're going to reach a point where you no longer have good enough data, and then you have to start analyzing your cases. And so it's a process that we've started doing now, trying to understand what is driving a disparity or what is driving a problem with a particular type of case. And so we work with prosecutors, we work with communities who posit theories as to why they think a problem is happening. And then we review the cases to try to see, to collect that data that's not currently in the system, to do a better job analyzing it. And as we figure out what we think the problem is, we try to bring as many people to the table, not only the leadership of offices, but the line attorneys, because the more line attorneys are involved in understanding this and contributing and making sure they trust the data, the better our results are going to be. Collaborating with members across the system, whether that be judges, defense bar, members of the community, to try to understand their perspectives, and to try to find solutions together, because these problems are hard. These are problems that most prosecutors don't have the skills on their own to solve, that most communities don't have the skills on their own to solve. So we have to bring together not only different skill sets, but different viewpoints in order to solve the problem. And then as we begin making solutions, you've got to measure, and then you've got to iterate. I think so often in policy circles, we make a policy change, and then that's the end of the day. One of the things I've learned from working with data scientists and the tech people is that there really never is a final product. You keep iterating until that product is no longer useful, and then you've got a new product. And so I think as prosecutors, we don't often think about this. You know, we write a brief, we file it, and that's the end of it. It's the end of the product. But we have to constantly be improving, and where we see ways that we can tweak our products, where we can see ways that we can tweak our policies, we have to continuously do that. We have to continuously do this from a standpoint of learning and better. Now, I understand why a lot of prosecutors and law enforcement in generally don't want to do this, or why they're reluctant to do this kind of analysis, because it undoubtedly will highlight many of our shortcomings, some of which we know about but don't want to talk about. But more surprisingly, a lot of those that we didn't even see coming, as we've heard a lot of the other presenters talk about today. But at the end of the day, this will allow us to better serve the communities that we serve. So I want to walk through a little bit of how we analyze this problem, and analyze the problem of dismissals, and how I think data can help prosecutors solve some of these problems. So this is a mock-up that we're working with one jurisdiction. It's not final yet. But when we tried to look at some of the data in the jurisdiction, I was interested in a few different things. I was interested in dismissals because I wanted to know what percentage of cases were getting kicked out. But I think when other people talk about dismissals, they're talking specifically about every case that gets dismissed. So that's grouping things like dismissals for plea bargains and dismissals for insufficient evidence. For me, that's a really big difference between if you're dismissing a case because it's a plea offer and you're doing it in exchange for some global resolution, and whether or not you're dismissing a case for insufficient evidence. So as you see from this particular chart, we divided it up because plea dismissals may tell you something about how you're plea bargaining, but it's not going to tell you about problems of the cases coming in. This number right here that's in the dark orange, those are cases dismissed by prosecutors for problems associated with the case. And that means that all of that time, it's about 20 some odd percent, I think 27% for that year, those were cases that prosecutors decided should not be in the system. Now, sometimes that's because a defendant dies, so I don't really count that. Sometimes it's because your victim or witness doesn't show up, so that's also a different problem. So we wanted to try to understand specifically, number one, how long was it taking for cases to be dismissed? And as you could see, it was taking quite a long time. And more importantly, how was it affecting cases for insufficient evidence? And so this particular office kept good data on why they were dismissing cases. I think a lot of offices are keeping this data. Why are cases dismissed? So sometimes cases are dismissed because they're diverted. Sometimes they're dismissed by judges at a preliminary hearing. That's a particularly bad case. But this insufficient evidence number, I think, is something that people should be understanding, because these are cases that prosecutors have utilized their power to get cases out of the system because we can't meet our burden. And what I found particularly troubling when looking at this information was that Black defendants were having their cases dismissed 3 times more frequently for insufficient evidence than white defendants. Now, to me, that signals a problem of people coming in the system and a problem of policing. Because as prosecutors, we know sometimes we get cases where the car stop is questionable. Sometimes we get cases where the search was illegal. Oftentimes we're dealing with this one by one. We make the best decision we can and we dismiss those cases out of the system. This is, to me, an excellent example of where prosecutorial power can be used to make our system as a whole more fair and more just. Every office should know how many cases are being dismissed for insufficient evidence, why, and who is being affected by that. Because as we're beginning to draw down into the qualitative study, we are finding that a lot of these cases are driven by car stops. Now, communities of color understand that they are being stopped by the police in far disproportionate effects. And that's a problem, because number one, it's an inefficient way for the police to be using their resources. It is terribly detrimental to the communities that we serve. And ultimately, it is not leading to getting more guns and drugs off the streets, because what is happening? We're dismissing all of those cases for constitutional failings. And so this is one of those areas that I think prosecutors should be looking at to figure out whether or not we're being fair and just. And we broke down those cases. And so we have a lot of different filters. And one of the reasons we ended up building these dashboards to begin with is, we thought we would analyze the data. I'd put my really smart analytics people on it. We would write up some data stories. We would come up with the problems that we found using the data, and then we would hand it to prosecutors, and then they would change policy. Prosecutors probably laughing. Of course you weren't going to do that, because we like to see the evidence. We want to hold everyone to a burden of proof. And so we ended up creating these dashboards, not necessarily to be public facing, though our goal is for them to be public facing once we feel confident that the data is sound and that we have considered all of the various contexts in that data. But you can see that dismissal rates are very different based on those cases. So domestic violence, very high percentage of cases being dismissed, and almost always that's being driven by witnesses not participating in the system. And one of the main reasons is it is taking entirely too long for those cases to be resolved. So it's not surprising that domestic violence victims who may have been cooperative at the beginning of an investigation are less so 2 years later. And so if we want to fix that, we've got to do better jobs with victim witness support, and we've got to do a better job moving the cases through the system faster. That is the bulk of my presentation. I want to have some time. I think I don't remember what time I was supposed to stop, but I want to have time for questions if there are some. And turn it over to you, Marion.
So have you been able to look at what changes offices have been able to make? I know we can see what we think would be the changes, but have you seen offices actually put in place, for instance, things like changes in the victim witness practices, ways of getting cases moving faster in response to what their data has been able to tell them?
We're still very early. Like I said, I left about a year ago to get this started, and we're seeing a lot of progress in understanding the data and identifying the problems. The places that I look to for innovative solutions in terms of interesting things, whether or not I'm a big fan of diversions, pre-arrest diversions that get people out of the system. I'm a big fan of the work that Yolo County is doing in trying to get restorative justice. I think a lot of these things, there's some great pre-screening that's done where police departments have to call in to prosecutors before they even make an arrest to determine whether or not they've got sufficient evidence, which mitigates against bad arrests and the consequences of that. The problem is that those offices don't also have really good data collection. And so what we're seeing is anecdotally really interesting reforms, and we're seeing data-driven organizations. Now, I think we're beginning to see outputs in places like Philly and San Francisco and in the bigger jurisdiction, Cook County, where I think we're going to see some of the best innovations are going to be in your medium and smaller sized jurisdictions, because there's less politics. I mean, there's politics in all of this, but there tends to be more cooperation or more ability to cooperate. And I think that's where we're going to see some of the best innovation. And so where we can link those innovative ideas with the data is where I think we're really going to move the profession and overall improve the equity of the criminal justice system as a whole.
All right, we're getting a couple more questions. One is, in the analysis of the cases in the dismissal situation, do you know how many cases or what kind of data set they had to begin with and over what period of time that reflected?
We were looking at data that goes back to 2015 up until the pandemic. We've stopped our analysis for right now to the pandemic because what we're trying to understand is overall trends when the system is functioning normally. Like many jurisdictions that haven't been having trials and haven't been moving cases the normal, there's a major distortion. So that's what we're looking at in terms of that. In terms of cases, I don't want to give you the wrong number because I have a lot of numbers mixed in my head. You know, sometimes we look at things at the warrant level, which is at the charge level. Sometimes we look at things at the case level, and sometimes we look at things at the defendant level. And it depends what we're trying to measure. And I think, you know, as people think about what data they're collecting, you know, one office I work with looks at everything at the charge level, which to me, I thought was really strange. But that's how they think about cases there. I tend to think about it as grouping all like charges together. And sometimes people want to think about it at the defendant level because depending on what policy you're talking about, which unit you're measuring matters.
So for offices that are newer in this process, we have a question about where does the planning start? How do you identify the issues before you collect the data? Or do you need to get some data and start doing analysis first?
You know, I think it depends on what do you want to do. You know, for the people who say, I want to divert cases, I believe that prosecution should be reserved for the most violent, serious crimes. Well, then you need to collect that information. I mean, obviously you need to know who's in the system and what they're being charged with. Most case management systems, if you have one, should allow you to do that. And one thing I didn't really talk about was the role that lawyers play in the quality of your data. Because when I was a line prosecutor, I was terrible at inputting data. And I'll tell you why. I mean, I was always on the naughty list. We get the email, like they were good at knowing who didn't input the data, but they weren't very good at collecting better data. And the reason why was, as a prosecutor, I never saw the benefit of that data. It didn't seem to me that they were collecting that information for any legitimate office management purpose. And as it turns out, they weren't. And so, yeah, I was bitter about inputting how I was spending my hours if no one was going to use it. But if I tell you what we're trying to understand is, are we giving the same plea offer to similarly situated people? Well, what information do you need for that? If you're trying to figure out, are we dismissing cases equally across the board? You need to know why people are dismissing cases, because you need to differentiate between the defendant who died, the defendant who was found incompetent, and the case dismissed for insufficient evidence, and the case where the witness didn't show up. And so I think depending on where your concern is, for me, I'd put my money at the front end. I want to know how we're screening cases. I think one of the biggest areas for reform and prosecution, and one of the areas that I hope in time we will be able to contribute to, is how to better identify cases, how to make sure from the beginning that only the cases that are best served by prosecution are in the system. Now, that also takes a step back to look at it more holistically, sort of crim law first year. Why do we punish in the first place? Deterrence versus utilitarianism versus incapacitation. Like, we're really good at incapacitation and we're really good at retribution. I'm not sure that we're that good at deterrence, and I'm not sure that we're that good at our utilitarian function as prosecutors. So for me, I would focus on the data that helps us prove up those things.
And what about probation or prison data? Do you see that, if we're able to access that, as being helpful in this work?
We right now are only relying on prosecutorial data. And part of the reason why we started with prosecutors is, number one, I think that they are the decision makers that have the biggest ability to influence the overall criminal justice system. And number two, they're usually able to give over the data on their own. Whereas you get into the prisons, you get into the police, the politics of just getting the data becomes a lot more complicated. And so who are the decision makers who can make decisions and have access to that data, and can we work? Now, as we have started working in some jurisdictions, local police have also found out what we're doing. They've learned about our dismissal project, and they want to know more. How do traffic stops affect dismissals? And so we've recently gained access to some policing data that we're going to merge within that prosecution data. Overall, I think that this holistic approach works best where you've got uniform systems, where not only are the justice actors in play, because one of the big problems we have is mental health and addiction. I don't know how many offices know how many people you prosecute that have mental health issues or addiction issues, but my guess is it's a huge chunk of your population. And so finding ways to link that with health data, because the people who are frequently appearing in our courts, usually with low-level offenses, usually with addiction or mental health issues, are the same people that are regularly appearing in our emergency rooms because they don't have health care. They're the same people who oftentimes have housing instability. And so the more we can link a lot of these different data sources, the better we're going to make holistic decisions, so that we're no longer really talking about criminal justice, we're talking about public safety, because that's where the discussion needs to go. The problem is that everyone collects different data, everyone measures different data, and a lot of times those data are not easily merged. So one of the things that we're hopefully trying to do as we expand is to create the code that helps offices self-clean their data, so that we help you identify where your problems are, so that you then go fix your data and then you can rely on it. So that we can better link disparate data silos so that the police and the prosecutors can communicate. Now, there's not a whole lot of trust between prosecutors and the police, much to, I think, many in the community surprise, who often see us lockstep together. There's often a lot of tension between the decisions of those two actors. And so over time, we've got to build that trust. We've got to create the transparency so that the organizations that are encouraging those common metrics, that are encouraging those transparency, is vital. But then we got to do something with it. We've got to make changes, and we've got to show that those changes are working, and we've got to reduce the harm that we cause to the community. We've got to increase our positive goal, and we've got to think about public safety differently. There was a question earlier about recidivism and measuring recidivism. I think sometimes we look at recidivism, we just talk about, well, have they been arrested again in the last year? But what we're seeing in certain communities where the arrest rates are massively disproportionate out of arrest, where drug use is we see, as we see massive bad arrests for low quality crimes, that affects criminal history, that then affects down the scale how long people are in jail for. And so we've got to think more holistically about all of this.
And we've certainly heard today about lots of wonderful collaborations and things that people have been able to get funding to do. But if you're an office that doesn't have that collaboration and doesn't have some funding, is there a way to just start this work on your own, do you think, and then maybe build yourself out to getting that collaboration?
One of the things that we're hoping to do is to make that collaboration easier, because I spend a lot of time talking to prosecutors, and I spend a lot of time talking to academics and data scientists. And as it turns out, prosecutors really want analysis, and academics and data scientists really want access to data. So one of the things that we're doing is bringing together those two parties, because at the end of the day, the only way to address this as a national problem is to help all of those counties. So we are building our list of partners. Ideally, we will link those partners with a locally based prosecution office, because I think in order to sustain this moving forward as we move on to new jurisdictions, we're trying to create a community and a culture around not only transparency, but problem solving. I think our politics in America have forgotten how to solve problems. It's like, this isn't a right or a left thing. It's we lack the ability to solve problems. We lack the ability to talk to each other in a normal way. And as a result, we just see so many of these problems that have been around forever just falling apart. So we're hoping to be able to link more offices with data sciences. Now, what are we looking for in partners with offices that we work for? As of right now, our model is not to charge offices, partly because I don't want cost to be a barrier to doing this important work. Now, when we're starting off, we're looking at who's got good data. So who's got case management system, who's been collecting things. That doesn't necessarily mean their data is perfect. I've got some really great data people who figure out what you need to clean up your data and to develop those scripts. It usually takes like 2 to 3 months before we think your data is good enough that we're going to start analyzing it. Our hope is that as we build over time, we're going to be able to do that faster. And I think it also depends on what your case management system looks like. And once we get that data cleaned up, it's not very hard to find the people who want to work on and analyze it. It depends on what your problem is that you're trying to solve. If you want to work on pleas or sentencing or diversion, lots of people out there who want to do this work. And it's about creating those communities and those partnerships.
And last question, in terms of, the question is in terms of low-level cases, besides looking at what the impact is in bail in those situations and looking at the dismissals, what else should officers be looking at?
I think you should be looking at how much time you're spending on it. And then you have to do an evaluation of, do I want to be spending all of my resources on that? A lot of times I hear prosecutors say, we don't choose who comes in the door. Absolutely true. But you choose what happens as soon as they come in the door. And so if you are massively misspending your resources by devoting hundreds of hours, particularly, let's start with the cases that are going to get dismissed. I had hundreds of cases, half of which got dismissed. Why was I wasting my time on that when we could have been spending our resources on the cases that matter to the community and that are going to have an effect on public safety? So I think it starts off by understanding, how are we spending our resources and doing a real deep assessment? Do we feel comfortable with that? And, I always hear people say, we don't have money for this. Well, you have money somewhere. We all have budgets that are significant enough. So I think it starts with knowing what's in your system.
That's true. Thank you. Thank you so much. I'm sure we have so many people here in Massachusetts looking for partners. So I feel very confident that you'll be hearing from people here. But thank you for being a part of this with us.
Take care. Thank you, everyone.
Thank you.